A horrible story, but with at least to some extent a good ending, and partly because of that good man sitting at the end of the table. Razi, you've done lots of cases and lots of experience, but I mean, what is your overall view about how you take this forward?
I've got to say, what I want to concentrate on is probably the most boring aspect of libel law, and that's costs, because I think it's absolutely crucial and vitally important to where we are at the moment. But listening to Zoe, I just noted down a couple of what to me sounded very interesting sort of sound bites, because it's interesting that she described herself as having to defend an attack, and I think sometimes it's forgotten how claimants feel who feel they've been defamed. They feel they've been under attack, and it's the claimant which is defending itself from an attack on their reputation. And Zoe is an example of an extremely erudite and media-savvy claimant. I can give you examples of, for instance, a 19-year-old who's been accused of being a terrorist or an Islamicist in the newspapers. And other examples, probably more well-known ones, of people being called paedophiles when they're not. And the effect of that sort of allegation that's made, especially in today's world with the expansion of the media and the ability of mass communication, is absolutely awful. And you can hear Zoe and how she felt. And she's a somewhat enfranchised person, I'd say. If you take the example of somebody who perhaps hasn't got as much access or is much aware of what can be done or what that person can do, then you can see how important it is that access to justice is available. The problem isn't just with the substantive law of libel, and my purpose here today isn't to talk about substantive issues, my own reason for being here. My reason for being here is costs. There is a massive problem at the moment with costs in defamation proceedings. The current regime of CFA and ATEs allow solicitors, and my firm acts approximately 50% of claim and 50% for defence, so I've got no particular axe to grind. But the current regime allows solicitors to recover double their fees if they win in a libel action. Now, in reality, that often means that the amount of money they can recover from a defendant publisher may well exceed £1 million if the case goes to trial. Now, there may be very exceptional cases where that can be justified, but I think that's the biggest problem facing the defamation area today. The current regime allows solicitors to act on their normal charge-out rate, and those rates are between £350 to £400 an hour. And if they take the case to trial and if they win, they will recover double that amount. And even if the case is settled before it goes to trial, the defendant publisher is liable for double that amount. And that, to my mind, having acted for defendants, has a real chilling effect. Now, undoubtedly, claimant lawyers to take on the risk must be compensated. There must be some inbuilt safeguard for the cases that they're asked to take on that they're going to lose. And there is, to my mind, a legitimate reason for having a success fee. But the success fee shouldn't be double the rates that the solicitors normally charge. And I know there's several of us in this room today that remember when there was no CFAs or ATEs, and legal aid in those days, when it was available, it's no longer available, wasn't available to defamation claimants. And I hope everybody agrees that we can't afford to go back to those bad old days when only the very rich could afford to litigate for their reputation. So we've moved on, and it's important in today's world that everybody has access to justice. Now, how can we ensure that that access is available to everyone? Lord Justice Jackson makes certain proposals, and his proposals are essentially that the CFA success fee be limited to 25%, and that 25% is not recoverable from the defendant publisher, but is recoverable from the damages. That's number one. Number two is the AT insurance. Now, I'm not sure if everybody in the room is familiar with AT insurance, but The problem with the legal system, the cost system in England, is that you need to be able to pay your own lawyer. CFAs cover that. But you also need to be concerned that if you lose, you're going to have to pay the other side's costs. Now, if you're a person of normal means, you earn a decent living perhaps, even if you earn a decent wage, you couldn't afford the other side's costs if you were to lose an action. And that would mean you perhaps lose your house and become homeless. It would be too big a risk to ever take on a newspaper publisher, for instance. ATE insurance gives you the possibility to get insurance after the event, ATE, the premium for which is payable by the newspaper if you win. But if you lose, the insurer pays out the other side's costs. So both those elements are vital to ensure access to justice. Lord Justice Jackson says that the ATE premium should not be recoverable from the defendant, and again should be recoverable from the damages. Now, in the vast majority of defamation cases, the damages that are settled, because the vast majority of cases are settled before they go to trial, the damages are agreed at way less than £100,000, for instance. They're often in the region of between 5, 25, 30,000. And that's partly because the offer of amends regime has drastically reduced the amounts of damages that the defendant would have to pay if they're quick to apologise and they realise they've made a mistake. Now, the problem is that if Lord Justice Jackson's proposals are implemented, no sensible claimant is ever going to be in a position to bring a defamation action, because the lawyers, would have to be willing to take on the case on only a 25% success fee. Maybe that's possible. But if that 25% were to be recoverable only from the defendant's damages, and the ATE were to be recoverable only from the defendant's damages, it will effectively mean that, in my view, very few claimants will be in a position to bring libel actions. Now, I think the problem is, I remember the time when the pendulum was very much in the newspaper's favour. In those days, you didn't have legal aid for defamation cases. The newspapers were in the driving seat. Unfortunately, what's happened through the ATE and CFA regime, the pendulum has swung way the other way, and it's had a chilling effect because the claimants are now in the driving seat and their lawyers can make too much money out of these sorts of cases. So, to my mind, there needs to be a balance. And the balance is one that hits the right balance between the amount of money that the system needs to generate for claimants to be able to bring cases and be represented, and Zoe's a good example of a situation where that was necessary, that there's sufficient give in the system to allow claimant solicitors and claimant barristers to take on those cases, and for the ATE premium to give protection to claimants in those situations, but it not to be at the levels that it is currently, which undoubtedly has a chilling effect. Even the most prominent newspapers or publishers can't afford to pay bills in the region of 1.5 million and upwards. It's simply ridiculous. And to my mind, the solution is available. And the solution is to limit the success fees, not to the current 100%, but to cap them at 50%, and to stage those success fees so that they don't go from nothing to 100% shortly after the defence is served, but to have stages right the way through the litigation, to allow the defendant to continually assess where they stand, and ultimately, if they feel that they have a good prospect of succeeding at trial, fair enough, but the success fees are limited at 50%. But if they settle earlier than that, the success fees will be a lot less. And in my view, I don't want to go into the details here, but I've set out my proposals, and my proposals would be something like 20% pre-action, 40% at the time the claim is issued, 60% when pleadings are closed, etc., etc. That's the fine detail. But I think that would work. And privately, a lot of clients I have in the media would be willing to live with that regime because it would drastically reduce the exposure that they currently have to meet. And to my mind, that's a workable regime whereby whereas Lord Justice Jackson's proposals will not be workable. And I'm afraid if Lord Justice Jackson's proposals are implemented, they will mean that a vast majority of people will not have access to justice in this area. And that's my concern.
Now it moves to the floor and for your participation. It seemed to me that we were really very lucky in having the riches of the panel, with not only a claimant and a coal-faced lawyer who does all of that. We also had our senior practitioner judge. We also had someone speaking about the concerns of ethical journalism and the principles in there. I'd like to hear contributions from the floor on some of those very interesting suggestions that were made about reversing the burden of proof, about creating new strengthened or statutory defence of public interest, a defence of honest journalism raised by Kevin, and the whole problems about multiple publication in our new world, the problems of costs, and then something that everyone touched upon, the business of early resolution, trying to find other ways of resolving things. Please, can I have hands from the floor? When you stand up, can you introduce yourself and then address us?